I know everybody's got a lot of things going on, so thank you very much for checking in. There hasn't been a whole lot of new information, but we did get a couple of questions, so I want to start with those and then just open it up and anybody can ask any questions you have and we'll go through them. So the first question that we got was, will the campfire settlement with PG&E relieve PG&E of all liabilities? For example, if there was a diseased tree that was damaged in the fire and it dies years later, could you sue them? The answer to that question is yes. The campfire settlement will completely wipe out any liabilities that PG&E has for the fire. So if, for example, you have a tree that's damaged, we need to make sure that we recover for that. Typically, that is something that our arborists look at. So when they look at the trees, they're not just looking at trees that are already dead, but they're looking at trees that they are not going to make it, and they are calculating that in as well. However, if you have any questions at all, please take a look at the tree report. We're happy to send that to you. Just let us know that you'd like to review the tree report for your property. We'll send it to you, and you can say, okay, I have concerns about this tree. Our arborist can talk with you, and we can get that sorted out. That's a good question. The next one, and this was something that was in the news, I believe it was 2 days ago, although it may have been yesterday. Is it true that Bill Johnson, the interim CEO, is retiring June 30, and will that affect our settlement at all? The answer is yes, Mr. Johnson is retiring, and no, it will not affect our settlement. This was something that I was also curious about, and so I checked in with actually Tom Wagner, who is the head of the group that now owns PG&E, and what he told me was this, that while they certainly all respect Mr. Johnson, as I'm sure you know, he was the head of the Tennessee Valley Authority, which is the largest utility in the country. Everyone respects him, but he was viewed as an interim CEO. He was somebody that they wanted to have come in after the debacles that they'd had in 2017, 2018, sort of right the ship, and then he was going to retire. He's of retirement age, and he was not somebody that they viewed as a long term. So the person that I've heard is going to be replacing him is someone named Bill Smith, who is from AT&T. It's not clear if he is going to be the permanent CEO or if he's going to be there on, again, on an interim basis, but he's the one that they're bringing in. And I think what they're trying to do is update and modernize PG&E, and so they're going with younger people and newer executives. So that's what's happening with Mr. Johnson. In terms of whether it will affect the settlement, the answer is no. This is something that they expected was going to happen, and I think bringing in the new CEO does two things. Number one, it really breaks all of the prior ties with PG&E. Again, the CEO who was in charge in 2017 and 2018 during the fires, Geisha Williams, was fired in January of 2019, so she's been gone for quite some time, but Mr. Johnson has been there during the interim, and I think a lot of people, both in the public and in the governor's office, wanted him to go because he was associated in a lot of people's minds with the old regime. I think what they want to do is bring in a new CEO, somebody that is going to cause more excitement on Wall Street and is going to get the stock price up. At this point, it does appear pretty clear that the vote is going to pass. Obviously, there's no guarantees, but the responses have been pretty overwhelmingly in favor of it. So at this point, it's really in everybody's interest for the stock price to go up so that the stock that the trust owns, which is, again, at least 22.4% of the new company, when that is issued, it's going to be on as advantageous terms as possible. And we're hoping it's going to be worth not just the $6.75 billion that's projected, but more than that as well. So those were the two questions we have. Two things to keep in mind. One, we are going to have a town hall with a number of other attorneys. This will not just be me, but it'll also be Michael Watts, Rich Bridgeford, a number of other attorneys that, while they're not part of our immediate group, they're attorneys that we've worked with throughout this process, were involved in negotiating the deal. And so the idea is that we want to have as many people as possible hear from their attorneys at the same time. So there's not this, my attorney says this, my attorney said this. This way, I think there's going to be 6 firms involved, and collectively we represent, I think, around 35,000 people. So the idea is going to be, this is an opportunity for all of those people to hear the same message from their attorneys and to ask questions. So any question that comes in, everyone will get to listen to it. The way that we're going to do that is you will receive a call shortly before noon on Saturday, which is when it's going to take place. If you'd like to stay on the call to listen in, feel free. If you'd prefer not to, hang up, no problem. The other thing is, and this was something we talked about a little bit last week, and it's in the update letter, but I just wanted to stress it because I know the texts can be inconvenient and, frankly, annoying. Nobody likes to get them. But again, there was a problem with Prime Clerk. And again, Prime Clerk is the vendor that the bankruptcy court hired to calculate the votes. Unfortunately, for some reason, Prime Clerk didn't take into account the fact that many people wanted to vote using their cell phone. Again, Prime Clerk encouraged people to vote electronically, and that's the way they set it up. But the problem is they are not able to accept votes via cell phone. I guess technically they can, but it requires a number of times trying before you can get in. And so most people don't have the patience and are unable to vote by cell phone, which is completely understandable. So we talked with Prime Clerk and we came up with a workaround system to allow all of our clients who want to vote by cell phone to do so. What we've done is we're texting to everyone a ballot and allowing them to either say accept or reject, vote yes or no on the plan. If you've already voted, don't worry about it. You can just delete it. But if you're one of those people who wanted to vote by smartphone, whether it's an iPhone or any other kind of phone, and you didn't have the opportunity because of this, again, completely Prime Clerk's fault, not your fault, it's Prime Clerk's fault. If you had that situation, then what you can do is just text us yes or a no. We'll get that, then we can log on and vote for you with Prime Clerk. We keep a copy of that text, which is why we need the text. We can't just have you call in. We have to have something so that there's a record of how everyone wants to vote. And then we just keep that in your file. And if it's ever an issue, then we can say, okay, Mr. Smith asked us to vote on such and such a day. He voted yes, we logged in, we did it for him, and that's how it happened. So again, I want to apologize. I know it is inconvenient to receive these texts. This should only happen for the next week or so, but we want to make sure that everybody has the opportunity to vote. And because of this issue with Prime Clerk, we're having to send this out. The other thing is we're working with a number of other firms so that all of their clients, as well as our clients, can do this. And everything is being coordinated through the Watts Guerra firm. They're sending out the texts. So while it should look to you as if it comes from us, at the very bottom, there should be some information saying Watts Guerra. If you get that, that's why. As always, if you have any questions, please give me a call, give any of our other team members a call. Although we are practicing social distancing and the offices are closed, all of us are working remotely, so you can call us at any time. So that is the pretty much everything that I wanted to cover. What I'd like to do is just open it up and answer any questions that anybody might have.
If you have a question, please unmute yourself, and we'll be more than happy to answer your question.
Oh, he asked about Monday. That's what I'm here. He's good at 2:30 in the morning. Hi
there.
I'm sorry, what? Okay, just so everybody can hear, if you're not speaking, can you please put it on mute? Okay, thank you. All right, so who has a question?
I have a phone number ending in 3666 had a question.
No.
No, okay.
I have Michelle Nixon.
Michelle, did you have a question?
One second, let me unmute Michelle.
Hang on one second. She was going to unmute you. Okay, go ahead.
Okay, thank you. There's been a lot of discussion about there still being another plan on the table. I know we've talked about this before, but just today there's many conversations that if individuals hold out, there somewhere another plan for 13.5 billion in cash that will come up somewhere if we, you know, vote this thing down. So I don't know where this information stems from, but can you clarify that for us?
Yeah, so that's a good question, and I think it comes from there's been a lot of frankly misinformation about the consumer-owned utility proposal, and I think that's where this is coming from. In terms of a plan, and this is something that's important to remember, in bankruptcy terminology, the word plan is a term of art. And what it means is that there is a proposal for how to get the company, in this case PG&E, out of bankruptcy. And you submit, if you are a proponent of the plan, all of the information that the plan contains, so how you would deal with each of the creditors, and then you provide all of the information regarding the financial backing for the plan. And in this case, everyone agrees that the total amount of financing needed is about $59 billion. Obviously, there are a number of different creditors, and everyone is entitled to a certain amount, but the overall amount is $59 billion. So initially, there were two competing plans, and a group of bondholders submitted a plan, and then PG&E, through the stockholders' equity, also submitted a plan. And these two plans basically mirrored each other. In fact, what had happened was, and we talked a little bit about this before, we essentially went back and forth between the two plans to get them to come up. You know, initially both of them were below 10 billion, then they raised it above, then we went back and forth, then the bondholders got to 13.5 billion, but only 1.5 billion was in cash, the rest was in stock. Then we got them to go 50-50. Then we said to PG&E, the shareholders, if you want us to go with you, then you have to match that. They did. So those two plans were virtually identical in terms of the financing. They both had 6.75 billion in cash and then an estimated 6.75 billion in stock. Again, both of them relied upon this formula of earnings to net earnings to share ratio, and it was 14.9 for both. And so those two were competing. We ended up going with the PG&E shareholder plan, and then the bondholders ended up negotiating a deal with the shareholders. So they withdrew their plan and they supported the current plan. The current plan is the only thing that is being voted on, and it's the only thing on the table. If it fails, then the court has implemented or adopted a contingency plan, which calls for a transition officer to be appointed and PG&E to be sold off piece by piece. Again, that likely will take 2 to 3 years, may take a little bit longer. And because it's very rare to get anywhere near full value of assets when you have a bankruptcy sale, we anticipate people will end up getting about 75 cents on the dollar. Could be a little less, could be a little more, but that's what we think. The confusion comes in because in November, the mayor of San Jose, Sam Liccardo, proposed a consumer-owned utility idea. And he got several other mayors and a couple of counties to join in a letter that he sent to the Public Utilities Commission, the CPUC, in which he said, I think the citizens of California would be better served if instead of having PG&E continue on as a for-profit entity, it was in essence municipalized and it became a consumer-owned utility. And that, I mean, there's certainly a lot of people who think municipal utilities are better than privately owned utilities. But the problem with this was it was not a plan. It did not have, it wasn't an official plan. It wasn't written up. It didn't have how everybody was going to be dealt with. And it didn't have any information, and this is the most important part, about the financing. This proposal acknowledged that it would take $59 billion, but all they said was, we believe we will be able to raise the money if PG&E or the governor submits this plan as an alternative. That did not happen. Any individual who wishes to can file a motion with the court and ask to have a plan considered. Whether fortunately or unfortunately, no one did so in this case. So there was never a time when anyone filed a motion and said, we have a plan for a consumer-owned utility and we want that to be considered. Because of that, there is no consumer-owned utility plan. Now, there are some people who have said that if this plan fails, the current plan, then the consumer-owned utility will be revived and it will pay everyone 13.5, and by everyone, I mean it will pay the trust 13.5 billion in cash by, I think the date they gave was September 30th. And, I mean, obviously anything's possible, but I just think it's very unlikely. First of all, in the bankruptcy process, in order for a plan to be considered, it has to be submitted to the court, approved, and then sent out for voting. That hasn't happened. But more fundamentally, it is impossible for me to imagine that there is $59 billion in financing for a nonprofit plan, which is what this would be. It would be consumer owned, so there wouldn't be any profits. I just don't see where that $59 billion is going to come from. And it's, in my view, absolutely impossible that it could be raised in the 3 months' time that we have, or the 4 months' time that we have. So again, there's nothing official. There's no official plan. There is this concept of the consumer-owned utility, but the state of California has made it clear that they are not supporting it. The governor supported this plan. The legislature, the chief proponent of municipalizing municipalizing PG&E, is a state senator named Scott Wiener from the Bay Area, and he has said, while I still believe that PG&E should be municipalized, it's not going to happen this year. That's a long-term project. So based on that, I don't think that's a viable plan. The last thing that I've done is reach out to anyone who has mentioned this, whether it's an attorney, whether it's Mayor Liccardo, the San Jose City Attorney's Office, and we've asked for all information that they have regarding this plan. The only thing we've received is a very short Q&A. It's on the website. It's document 306. So if you ever want to go to our website, we have a whole section on PG&E settlement, and we have a list of frequently asked questions. We have all the key documents that have been filed. Links to the town halls are there as well. You're welcome to look at it, and it lays out the idea behind the COU plan, but that really is it. There's no official plan. It's a proposal, and it is in the very incipient stages. So I don't think it's realistic that you would be able to get together this $59 billion in financing anytime soon, particularly for what is, again, a nonprofit plan. It's one thing if you're trying to raise money and it's for a for-profit entity where the people who are putting in the money can make a lot of money in return. It's entirely another to try to raise it for a municipal entity that is not for profit.
Okay, great. Thank you. Is that
Sure.
why they're also saying to hold off on voting because of the same concept?
The hold off on voting started because there was a group of people who thought that the current plan should be changed. They believed there were certain improvements. For example, they wanted to try and get PG&E to guarantee the $6.75 billion in stock. And they wanted a couple of other minor things as well. And our view was that While it would have been great if we could have gotten PG&E to agree to that, I mean, frankly, we would have preferred all cash and no stock. We understand stock has a risk. The problem is this was the deal that we made. We certainly think it's a good deal, but it did have that risk that the stock could be worth less than 6.75. And the problem is we had agreed that this was going to be the deal. So the individuals who were saying we should try and renegotiate the deal were violating the terms of the deal. And the problem is that gave the backstop companies, there are 70 different financial institutions ranging from JP Morgan all the way down to smaller financial institutions that had put up $12 billion in backstop funding behind the other individuals who currently own PG&E and are putting up their own money. And they would have the right to walk away from the deal if we violated the terms of the deal, which the renegotiation would do. So our thought on this, and it's not just myself, it's a number of other attorneys who were involved. We felt like what we should do is take this current deal and have the people vote on it. If the voters wanted it, then we would go forward. If they didn't, and if the victims said, no, it's not sufficient, then we could go back and try to renegotiate. But the concern that we have was that if the backstop partners walked away, which they would have the right to do with the renegotiation, then there was no guarantee the deal would still be on the table, and that would remove the right of the victims to vote on this deal. So that's where that started. That's why I didn't support it. And at this point, I think next week, everyone who hasn't already encouraged their clients to vote is going to do that as well. So we're anticipating that voting should be completed fairly soon.
Wonderful. Thank you, Jerry.
Sure.
Jerry, this is John Devers. I have a question.
Sure.
Okay. First question is related to the actual settlement. Now, my understanding is the passage of the plan is what precipitates PG&E's eligibility for participation in the wildfire fund. Is that correct?
Yes, there's one more step. The plan has to be approved. Then the bankruptcy judge has to sign off on it, make any changes that he believes are necessary. For example, he may make some minor modifications, but he can't change the essence of the deal. If he did, then he would have to send it back out for revoting. Once he approves it, then he can certify that PG&E has complied, they have a plan that has been approved, and they can exit bankruptcy. Once they exit, then they're eligible.
If that's the case, my question is, it seems to me we have little to no leverage at that point if PG&E does not make their August deadline for funding. Mm-hmm. So what are our options there?
Well, there's a couple. The one thing that could derail this plan, even after the judge approves it and certifies that PG&E can get out of bankruptcy, is if they fail to make their payments. The plan is contingent upon them making those payments. So if, for example, they fail to fund by August 29th, then all of us have the right, and it would be done essentially by voting. We would talk with our clients, we would meet with the other attorneys who signed the agreement, and then we can, through a majority vote, unilaterally walk away, in which case PG&E falls out of bankruptcy and essentially they're in default and the contingency plan goes in. So that's one leverage. The other is if they fail to make the payment by August or by September, then they begin to incur certain penalties that were instituted by the governor in order to encourage them to meet this deal. So we think they're going to, but the only leverage that we have is by pulling the plug on the entire deal and converting this into what is essentially a Chapter 7, where an individual who will essentially function as a trustee, a transition officer, is appointed and begins selling PG&E off.
Thank you. Additionally, I wanted to ask, in terms of the way this plan is presented, we're told that if the plan does not pass, there is a very strong likelihood that PG&E would just go into full bankruptcy and the sell-off of assets.
Right.
That requires us to, I guess what I'm asking is, in your honest opinion, do you genuinely believe that PG&E has no other contingencies they're prepared for should the plan initially not get passed? That is, do you genuinely believe at that point PG&E just says, "Oh well, I guess we're out of business"?
Well, I think what they would do, and I would bet a lot of money that what they would do, is they would ask the judge to do a cram down. So I don't believe that if the vote goes against them, that they are simply going to fold up their tent. I think they are going to do everything they can to try to get the judge to institute their plan, regardless of whether or not the victims voted for it. That's what I believe they will do. And I think whether or not the judge does that is going to depend upon where the vote comes in. My guess is if it's close, let's say 60 some percent, but short of 67% supported the plan, that's particularly in US elections. I mean, you rarely see elections in which one outcome gets more than 60%. Let's say it's 62%. I think the judge might say, okay, we're going to modify X, Y, and Z, and I'm going to approve it as part of a cram down. If it's 50% or 45%, I don't think he does it. So that's my honest opinion. It's possible the bondholders could come in and say, we have our plan and we'd like that to be considered, but I just don't think there's enough time for it to be voted on. So that's why I think that's very unlikely. I mean, just one more thing. To really, the reason that I don't think there are a lot of contingency plans in place is that unless the legislature votes to move the June 30 date and the governor approves that, because it would have to be a bill that was signed by the governor, PG&E ceases to be a functioning entity if it doesn't qualify for the AB 1054 money. And May 15th is the deadline for voting. So that gives them 45 days between the time of the vote and the June 30 deadline. That just really isn't enough time to have another plan and get it approved by the victims. They would have to do some kind of a cram down, and I'm sure they would try, but whether or not they'd be successful, I have no idea.
Apologize in advance because it's a little unfair, but you're the only person I can ask.
Sure.
And it is just out of curiosity, how much money is going to be attributed to costs to come out of that will be paid for by the settlement to blanket our local television stations with the commercials to vote yes on the plan? That also includes some people stating things that are particularly regarding payment and stock options that aren't even, legitimate in terms of how the plan functions.
Sure. In terms of the plan itself, and the money that's going to come out of the trust, nothing is going to come out of the trust for any advertisements of any kind. If what you're asking is, because I know there have been some ads both in Camp, in the Paradise area, and in the Santa Rosa area, those are put on by private attorneys. And so that's something that a firm is going to pay for, and that is their responsibility. It's not something that is paid out of the trust. Was that the question?
Yes, because they're extensive. They're playing on both cable. They're doing network broadcasts, and I'm seeing them on average on the cable stations at least once an hour.
Yeah, no, it does not surprise me. It's not something that we've done, but it certainly is something that other firms are doing. And I mean, it's ultimately it's their money. If they want to spend it on that, obviously they have the right to do so. It's not the approach we take, but it is something that some people are doing.
I have a question from Jerry.
Thank you,
Hall.
Jerry.
Well, hang on.
Oh, sorry.
Let's make sure John
Sorry.
doesn't have any other questions. John, did you have any other questions?
Thank you. I'm done.
Okay, go ahead. You had a question from who?
Jerry Hall.
Okay.
Jerry Hall, can you hear us?
Is it,
Registered under Jerry M. Hall. Unmuted.
okay. Do we have Jerry Hall?
Okay, we'll figure it out. I have another question submitted.
Okay, sure.
It says, what are the expenses expected to be? It was originally estimated at 2%. What is it now?
Okay. So the question is, for the individual expenses, is 2% still reasonable? I think it is. Again, typically it's going to be a little bit lower than 2%, but I think 2% is still pretty reasonable. Now, that's on average. There are going to be some cases where it's a little bit higher, some cases where it's a little bit lower. It all depends upon the individual expenses for your case. Obviously, the more experts you have, the higher your costs are. But I think 2% is pretty reasonable. And certainly as an average, I think it'll be below 2%, probably about 1.5%.
If you have a question, please unmute yourself, or if you have video, raise your hand and I'll unmute you.
You ready?
Anybody have a question?
I have so much darkness.
Michelle?
Oh, hi again.
Hi.
So there was some concern about the stock portion of the settlement not being covered by the backstop. And
Sure.
also there was another, some verbiage about if so many structures are destroyed that something changes with the contingency plan where that's concerned.
Yeah, no, those are two good questions. So yes, the main risk here, and in my view, the only reason anybody would want to think about voting no is the fact that the stock is not guaranteed. And I want to make that crystal clear. There is no guarantee on the stock. There are backstops for other things, but the stock is a risk. Now, again, we've had financial experts look at it. We believe that based upon the way this stock is going to be calculated, it is going to be worth at least $6.75 billion and possibly more, but we cannot guarantee that. So that is a risk, and I want to make sure everybody understands that, because in my view, that's the main risk in this whole idea, this whole plan. So that's one thing to keep in mind. In terms of the other question, that had to do with the right of certain backstop providers to withdraw if there was a fire between the time that PG&E filed for bankruptcy and the time they emerged from bankruptcy. And specifically, the Kincade fire was what a lot of people were worried about. I believe the terms, and I don't have them in front of me, so I'm going off memory, but I believe the terms were that if there was a fire that destroyed more than 500 structures during the time that PG&E was in bankruptcy, then the backstop providers would have the right to withdraw. As you know, the Kincade fire only destroyed 372, so that did not trigger that. And the Kincade fire, and this is something I want to make sure everyone understands, is completely separate from this $13.5 billion trust. Because Kincade is a post-petition fire, and because it happened after AB 1054, it is treated completely different. It is not part of the bankruptcy. It is it does what we call ride through, meaning that it's as if the bankruptcy hadn't happened. Once PG&E emerges from bankruptcy, then anyone with a Kincade fire claim, and we represent a number of people who have them, will be able to file suit and they'll be able to go after both PG&E's insurance, which for that fire is $430 million. And then if that's not sufficient, they can go after the AB 1054 money. So we don't believe that Kincade will have any significant impact at all on this settlement.
Great, thank you. One other question. There's been some discussion about the first amount of money being funded to the plan being secure, but anything after that additional first payment is not secure at all. So I don't know where that's coming from, but can you clarify that for us?
Yes, that has to do with the fact that the funding sources for the money is different. The first payment, which is $5.4 billion in cash, and which is due on the effective date, which again is supposed to be August 29th or before. But as John pointed out, our only leverage there, if PG&E does not comply with it, is to pull the plug on the deal, and then they begin to incur penalties in September. So again, we think they're going to do it, but there is no guarantee. That first $5.4 billion is backed up by the backstops. The other $1.35 billion, which is scheduled to be made in two payments, $600 million in January of 2021, and then another $750 million in January of 2022, is going to be obtained through what they call essentially loss of earnings credits. And what PG&E is going to be able to do is to apply past losses to and basically get tax credits, so they can apply them to their tax bills in 2021 and 2022. And so they're able to save this amount of money, and that's what they're going to use. It is correct that there is no guarantee that they will be able to use that specific mechanism. However, this is not the exhaustive remedy that we have. It's not like if that tax advantage doesn't work, then the victims don't get their money. We would have the right to then proceed against PG&E and to recover the money, because that's something that PG&E contractually owes us. So if they weren't able to pay it, then they would have to pay it out of earnings. And again, right now, their projected net earnings in 2021 are going to be well over $2 billion. So if they were to have to make a $600 million payment, that's not something that they would have difficulty doing. Same in 2022. And while obviously there are no guarantees, generally net earnings are pretty accurate, because we know exactly what they can charge based upon the permission they get from the CPUC. And we also know that with AB 1054, it's very unlikely they're going to have major losses like fires or something like that, because if there is a fire that is started by their equipment, they'll be able to take advantage of the benefits of AB 1054.
One more. Oops.
Sure.
If for some reason the vote goes through yes, fine, and then they don't follow through on their end, what kind of recourse do we have at that point? If they still, renege on their end of the deal, how would that play out in your mind?
Then the contingency plan kicks in. The way that it works is on August 29th, if they have not funded the trust with the $5.4 billion and the $6.75 billion in stock, then we have the right to pull the plug. If for some reason we were to choose not to, then they have up until December 31st to make the payment. If they don't make it by then there is a contingency in place that completely voids the deal. Judge Montali would then reassert control, and he would then appoint the transition officer who would begin the sell-off. So the contingency plan would take place. So in a worst case scenario, that's the way it would happen. Again, I think it's very unlikely that would happen. The main danger would be if we had some type of catastrophic event in late 2020. For example, if COVID were to reassert itself on a scale that we haven't seen thus far. That is something that could end up tanking the deal. We obviously hope it won't, but if it does, then what will happen is PG&E will be sold off part by part, and we'll have to proceed the way we would in a normal bankruptcy.
I see. Okay, thank you.
Sure.
Jerry Hall? Jerry?
Okay.
I'm sorry, we're having trouble hearing. I think we're going to have to come back. Do we have other questions?
I do have a few that were submitted.
Oh, okay, why don't you read them?
I have, when voting for a trust with multiple trustees, is one social or one tax ID sufficient for signing the ballot?
Yes. Yeah, that's a good question. So the question is, if you are voting on behalf of a trust, the trust gets one vote, any of the trustees can cast that vote. So if the trust has its own tax ID number, you would put that in, and then the trustee would vote on behalf of the trust.
And then related to that, when signing the ballot, does the trustee sign on the signature line or on the signature line that says other than claimant?
They would sign on the signature line because they are signing on behalf of the trust. The other than claimant is, for example, when you have an adult who is voting for a minor. Minors filed their own proof of claim, so they have the right to vote. However, the voting has to be done by an adult. So in that instance, you could have the parent sign for them, but they would do it in the space that says other than the claimant.
Okay, just submitted, can the attorneys drive towards an all-cash deal of 13.5 billion? If not, why not?
That's an excellent question. So the question is, can the attorneys renegotiate the deal and get 13.5 billion in cash? The answer to that is no. The deal has been signed and it's not going to change. If it's voted down, then again, PG&E would try some kind of a cram down, but there's no way to get the terms changed. And the reason for that, and frankly, the reason that we did not get 13.5 billion in cash, is that PG&E simply doesn't have it. They don't have it and they can't borrow it. Remember, and this is very important because I understand people are frustrated that the local government entities got 1 billion in cash, no stock, and the insurance companies got 11 billion in cash, no stock. But again, it's very important to remember that with the insurance companies, they had claims that were valued at almost $20 billion. It was 19.5. And remember, when they're talking about their claims, it's not like it is for an individual who might say, I believe that my damages are X, and then PG&E or the defense would come in and say, no, they're much smaller, they're Y. With the insurance companies, they're talking about money they actually paid out, or money that, because the claim has been asserted, they will have to pay out. Those are called the reserves. So with paid and reserves, they had 19.5 billion. And then with just paid, they had over 16 billion. So they took a reduction of over 40%. Because they were willing to take that enormous reduction, they were able to negotiate for all cash. Same with the local entities, and this would be the County of Butte, the County of Sonoma, the County of Mendocino, Clear Lake, all of these various entities, municipalities that were damaged in the fire. They negotiated for a huge discount. Their claims were more than $3 billion. They were probably worth about 1.5 to 2, and they accepted $1 billion in cash. So again, they took a reduction of between a third and 50%. Because of that, they were able to get cash. We were not willing to take that. We wanted a number that we believed was sufficient to get our clients paid 100 cents on the dollar or very close to it. That's where the 13.5 came in, but PG&E simply didn't have the cash. Because of that, we had to go with half stock, and that's why we did it that way.
And will the economic damages be paid out first?
Question is, will the economic damages be paid first? I don't believe they will. I think what's going to happen, and again, the final claims procedures will come out, I believe it's going to be in early June, but I think what's going to happen is everything is going to be submitted, and then there will be a final number that will be assigned. And that'll be done either by the claims administrator with the claimant accepting it, or if there's a dispute, then you can go to mediation, arbitration with a single arbiter, and if that is not acceptable, you can go to a 3-panel arbitration. Once that final number is decided, then I think what's going to happen is the trustee will pay out a percentage of that. It'll probably be around 80%. It'll almost certainly be somewhere between 75 and 85%, somewhere in there. And then the trustee will withhold that amount, let's just say 20%, until he is sure that there is enough to pay everyone. Because what they can't have happen is the people who get their claims in first get paid 100 cents on the dollar, then there's not enough money, then the people at the end get, 85 cents on the dollar. If there's going to be a reduction, it's going to be done on a pro rata basis, so it applies equally to everyone. And so because of that, the trustee is going to withhold a certain amount of money, and then, let's say it turns out everyone only gets 98 cents on the dollar instead of 100, then he would give out, instead of giving out the full 20%, he would give out 18%, so each person would get 98 cents on the dollar as opposed to 100. Following up on that, a lot of people have asked, what about attorney fees? How are they calculated? And I want to make sure people understand the attorneys are paid, and I can only speak for our group, but it's generally the same with everybody. The attorneys are paid based upon what is recovered, not on the amount awarded. So using that number, let's say that 500,000 is the final result of amount of your claim, but you're paid 400,000 up front. It's not like we get our percentage, our 1/3 of the 500. We get the percentage of what you actually received. So if amount is held back, then that's a portion of our fee being held back as well. We only get paid on what you received. So it's not a situation where if 80% is given, we take 1/3 of the 100%, we would only take 1/3 of that 80%. What do we have next, Drew?
Michelle?
Hi again. So, shoot, what was my question? Well, first of all, I know that you had mentioned that your fees would also be added on somehow to the amount of money that we would receive to help cover your attorney fees. I'm not sure how that was explained, or maybe I misunderstood you.
Sure. The way that the attorney fees are handled here is the same as they would be handled if PG&E was still the defendant as opposed to the trust. The defense in these types of cases, the defendant, PG&E, has to pay the attorney fees on the economic damages. They don't have to pay them on the non-economic damages, just the economic damages. And the reason for that is that the economic damages are available under a cause of action called inverse condemnation. And inverse condemnation is one of the few causes of action in American law that allows you to recover your attorney fees. Typically, under what's known as the American rule internationally, each side pays their own attorney fees. In other countries, it's different. But in America, we each pay our own attorney fees unless there is a specific fee shifting provision in the statute. The great thing about inverse is it has that fee shifting provision. And so because of that, PG&E has to pay the attorney fees on your economic damages. So the question becomes, okay, how do we calculate that? What we do is we figure out what your economic damages are. We add up your real property, your personal property, your alternate living expenses, anything else that's an economic damage, and we come up with that number. On top of that, we add the attorney fees for those economic damages. And then on top of that, we add the costs of litigation. On top of that, we add the non-economic damages, and that's the full amount. So that would be the amount of the demand, and that's how that is factored in. Then the ultimate payment, because you have to pay attorney fees obviously on non-economic and economic, is 1/3 of the total amount. So that's how it's done, and that's how it works out that PG&E will pay a substantial portion of your attorney fees.
Got it. And I know you had mentioned before that if this plan doesn't go through, those deductions, those huge deductions that these creditors or local entities have taken, that those will be off the table most likely. And then if this is renegotiated, we'll have to maybe look at having all that being paid out of that lump sum again.
Right, and that's a very good point. One of the things that will happen if the plan is not approved is that all of the discounts that have been negotiated go out the window. And it applies to us as well. I mean, we'll make the argument for the individuals that the individuals are entitled to more than 13.5. But essentially what it'll mean is that PG&E will be sold off, and eventually there will be a big pot of money. It'll probably be somewhere between 40 to 50 billion dollars. Out of that, everybody will be trying to get the most that they can. We'll obviously be trying to get as much as we can on your behalf, but the same will be true for subrogation. They'll argue that they're entitled to 19.5 billion, not 11. Same for the local governmental entities. They'll be arguing for 3, not 1. And so all of that will have to be decided by the bankruptcy judge. And that's why we say, if that happens, we believe that the total amount available for the individuals will ultimately be less than 13.5.
Okay, thank you.
Jerry, I have an additional question.
Sure.
Okay, first though, I just think it's important because this is, if we want to talk about the thing that sticks in the craw of victims, it's that when we talk about the insurers and the subrogation claims, the fact still remains, the majority of those claims, more than half of those claims, are not in the hands of insurers at this point. They're in the hands of hedge funds, some of whom are also have a stake in PG&E, and they have sacrificed nothing. They stand to make a tremendous windfall out of that 11 billion. So when we talk about concessions, when more than half of them, you know, it's not in the hands of the insurers, I'm not so sure about that. But my question is about the liquidation of the stock. And I'm aware that that has not been finalized yet. The plans have not been finalized yet. But I'm asking, in your opinion, we're aware of the fact that PG&E has a plan where they're selling additional stock. They're trying to raise these billions up to 9 billion of additional stock. They have a prior agreement to sell to hedge funds at a lower price than what it will be valued at when the victims get theirs. And I just want to know, in your opinion, okay, one, since none of this has been finalized yet, that they will not have incentives that are going to have a negative impact on the trust's ability to liquidate the stock. And that, again, that you're certain that there will not be any restrictions put upon the trust. And other than the common sense ones, in terms of you don't liquidate the stock at, you know, and destroy the value. But beyond that, that there won't be additional punitive things put in place that would interfere with that.
Sure. No, and those are all, I completely understand where you're coming from, and I understand why people would be upset about the fact that hedge funds bought the claims of subrogation. I get it. Unfortunately, that's something that the system allows, and that's why they were able to do so. There are, frankly, a lot of things about the legal system that if I had the ability to go in and change, I would change. But you know, a friend of mine said it best when we were in the town hall last week, and he said, look, none of us wanted to be in bankruptcy. We really didn't. We wanted to be in superior court where we could either say, pay this amount to our clients, or we are going to trial. Unfortunately, bankruptcy is where we find ourselves. And so within the confines of bankruptcy, and as you know, the bankruptcy process is set up to benefit the debtor, not the creditors. We have to do the best we can. And so, you know, with that backdrop, that's how we got to this situation. And I completely agree. It's not fair that hedge funds are able to buy these claims and make money, but the subrogating insurers were willing to sell them. The hedge funds were willing to buy. There's no law that prevents that. And so that's why they were able to do it. In terms of the question that you had regarding the stock, those are also very good ones. In terms of whether or not they have a deal with other hedge funds to sell to them at a discount, what they're going to do is basically do a stock offering. And in the event that they sell the stock on the open market, which is what people think will happen, then the hedge funds do not have, they don't get any special right to buy stock. But where the whole backstop concept comes in is in the event that PG&E is not able to sell all of the stock, then they have this backstop where they have a set price and where these financial institutions agree to buy the stock so that PG&E will have the cash necessary to fund the deal. So that is a contingency. It's not the first plan where, you know, they go in and the hedge funds get a discount. But in the event that they're not able to raise the capital any other way, then you're correct. That is what will happen. In terms of the reservation of rights or the restriction of rights, that's something that's being negotiated right now. And that's happening between the underwriters. And it's a group of underwriters. It's Royal Bank of Canada for the plaintiffs. And then I believe it's JP Morgan for PG&E. But they, together with a separate investment bank that was hired by the trustee, they're working out these underwriting agreements. And what we've been promised is that the underwriting agreements and the restrictions are going to be uniform. So as you said, there are going to be some common sense rules. If you own, you know, a particular amount of stock, then you're restricted in terms of how you can sell it. You can't sell, you know, 100 million shares in one day because you don't want the stock price to tank. But that will apply to all large shareholders. It's not going to be one set of rules for the trust and one set of rules for everybody else. So that's something that I can say with confidence is going to happen. Whatever the restriction rules are going to be, and there certainly will be some to prevent mass sell-offs, they're going to apply equally to all of the major shareholders.
Okay, thank you.
I have a question from Sean Harris. I want to unmute you.
Okay.
Yes, I was just wondering, whoever's handling the stock, what is their fees and percentage of that 6.75 million or billion?
Okay, to make sure I understood it correctly, are you asking about the fees for the underwriters, the people that are doing the deal right now?
If I had the stock and I was selling it off, I would be paying my broker a fee to do it and move it for me. I'm worried about that much money being sold, and what is their piece of it?
They pay the standard fees. I don't know off the top of my head what they are. I just know that the way it works is this. There is a financial advisor that is hired by the trustee, and it is, you know, a very high level bank, and they provide the advice, and then the stock is sold that way. So I don't know what the exact fees are. There certainly are fees, and you know, that is something we can find out. I just don't know what it is off the top of my head.
Well, I mean, I know they range, but it just seems like in a situation like this, that and the dollar amount and how much stock there would be, that it would be negotiated to a smaller percentage than a standard normal thing that was happening. And that was kind of my question, seeing what that.
My understanding is that it's not going to be based on a percentage because of the size. Instead, what they're doing is they are, that the trustee has hired an investment bank to advise them on when to sell. And so that's going to be what happens. And there's not going to be a broker who makes a commission based upon the size of the sale, because you're right. I mean, that would be astronomically high.
Yeah, exactly. So that was it. So you answered my question. Thank you.
Sure. Looks like we have Miss Loving. Is that right?
Yes, that's correct.
Yes. What can we do for you?
Yes. Well, I do support this plan, and I have voted yes on it. And I do appreciate really all the effort our attorneys have put into hammering out us a really good deal, in my opinion. But my question is, when I got money from FEMA, I was not taxed. I did not have to pay income tax on it, and it did not affect my Medi-Cal. And I'm low income and depend on that Medi-Cal. So my question is, if I do receive a settlement, will I pay income tax? And do you know if it'll affect my eligibility for Medi-Cal?
Okay, very good question. So two-part question. Number one is whether or not settlements are taxable. Number two is whether or not it affects Medi-Cal, or any other similar program, so we can expand it to everybody out here. The answer to number one is, first of all, I have to say I am not a tax lawyer. It's not my specialty. So I can give you the basics, but I always encourage everyone to speak to a CPA or tax attorney who specializes in this, and we're happy to give anybody who wants the names of people that we've sent clients to in the past. The general rule is that if you receive money for an economic loss, for example, if your home burns down, if you're a renter and you lose your personal property, if you receive money and you spend that money to replace your property, it is not taxable. There's no taxable event because you haven't gained anything. What's happened is you've been compensated through the judicial system, which only has one way of doing it, and that's paying money. And then you took that money and you replaced what you lost. So there's no taxable event. And typically you have, and again, this is something you should consult with a professional on, but 2 to 3 years between the time you get the money to actually spend it on replacing what it is that you lost. So that's the general rule, but there are a million exceptions. For example, if you were to take a capital loss, then obviously when you receive the money, you'd have a capital gain. There's all different kinds of intricate things. If, for example, you received compensation for lost income, then that would be taxable because the income would be taxable. So what I always say is the general rule is when you're being compensated for a loss and you replace what you lost, there's no taxable event, but there are a million exceptions. So please talk to a qualified professional. We're happy to give you a recommendation. In terms of the second question, this was something that we had come up a lot in the Butte Fire case in Calaveras County. And what we found is that it really depends upon whether or not the type of benefits you get are needs-based or not. So with something like Medi-Cal, my understanding is if you're disabled, then oftentimes it is not dependent upon how much money you receive, whereas if you're not disabled, then oftentimes it is. But what I recommend that all of our clients do who have this issue is to consult with an attorney who specializes in this. And we ended up forming a relationship with attorneys in San Diego who specialize in this. And what they do, if you have, for example, if you have Medi-Cal and receiving a settlement amount in a lump sum would make you ineligible, what they can do is set up what's called a special needs trust. And that trust can be set up in such a way that it pays for your living expenses, but at the same time, you're still eligible for Medi-Cal. So if anyone is interested in that, if you receive any kind of, whether it's disability, whether it's Medi-Cal, anything like that, please let us know, and we're happy to give you the names of those attorneys. There's obviously other attorneys. There's ones in different parts of the state. We've known these attorneys for quite some time, and they've been good for our clients, so that's why we recommend them, but there certainly are other qualified attorneys.
I have a question submitted via the chat. Instead of the trustee selling the shares and paying individuals, can the individuals have the shares transferred to them so they can sell the shares when they want?
The answer to that, and the question is essentially, can you accept or choose to have payment in stock rather than cash? The answer is no. And the reason for that, this was something that the trustee looked at, and we talked with them because several of our clients had indicated that they might want to accept payment in stock rather than cash. Ultimately, the trustee looked at it, and they felt that it was simply too risky, that there was no way they could do it fairly, because the question was, what would you get the stock, what would the value of the stock be? Would it be when it was issued, or would it be at the time that your settlement was reached? Because of that, and because there was no way to fairly do that, the trustee just decided we're going to pay out cash, and then if somebody gets cash and wants to buy stock, then they can do so.
Like Michelle?
I know you had discussed with us that the claims administrator is in the process of hiring, is it up to 250 individuals to help work on the individual claims and the
Yes.
process with each applicant? Do you
Yes.
know how those individuals are being, picked, and what their the criteria and the qualifications are for these individuals?
That I don't. I think they're going to be primarily individuals who have financial and data processing backgrounds, is my guess, because essentially what they're going to be doing is they're going to be taking in the information and then comparing it to other information that they have in this matrix they've developed. Michelle, this was something that we talked about yesterday when you and I spoke, but what they do is they get data from all of the other fires and they're looking at typical results. And then they have a window on either side of that. And if your claim falls within what they would expect to see, for example, for personal property for a home of this size, of this construction, then they're going to go ahead and approve it. If it's above that, that just means that we have to look at it more closely. And obviously, we all want that happening because we want to make sure that there are no fraudulent claims. But all it means is that we then show why it is that this claim is higher. And that's something we can do. And that's your attorney's responsibility to make sure that we can document that. So that's how that's going to work. So what the processors are going to do is they're going to get the information in, they're going to feed it into the system, and they're going to alert the claims administrator, this portion of the claim fits within what we would expect to see. This doesn't. They're also going to look at what we call the gating documents. And this is just making sure that each individual who makes a claim has a basis for it. For example, if you're going to claim that you lost a home, we've got to provide evidence of ownership of the home. We've got to provide evidence that the home was actually destroyed. We have to provide evidence if you're a renter that you lived at the home. So that would be either driver's license, address, rental agreement, anything like that. So all of those things, the gating documents, all that's going to be done by the lower level folks who are those 250. And that way, the more expensive people, the claims administrators, are just going to look at what the actual evidence is and make these determinations. And the hope is that we can streamline this and run it as cost efficiently as possible. It's still going to be very expensive, but the hope is that the first level of people will handle all the gating issues and will flag any specific issues that the claims administrators need to look at. Then the obviously much more expensive claims administrators, these are the retired judges and attorneys who are familiar with these types of cases, they will come in and then make their recommendations and submit an offer to each individual. That's how we envision it's going to work.
Great, I understand it a lot clearer now. Thank you.
Sure.
Jerry, one last question.
Sure, go ahead.
This is regarding the handling of the trust. I have no doubt the personnel that have been selected were picked because of their extensive experience and expertise. But my question is regarding the handling of the trust and the subsequent liquidation of the stock. Are the personnel that are going to be responsible for that, are they compelled by a fiduciary standard or just a suitability standard?
No, fiduciary. The trustee owes a fiduciary duty. John, are you there?
Yep,
Okay.
that was it in a nutshell.
Okay, yeah. All right, what other questions do we have? Okay. Does anybody else have any questions? Okay, well, I want to thank everybody. And again, I want to apologize that all these texts and calls are going to be coming out. Again, there was that issue with Prime Clerk. We just want to make sure that everyone has the opportunity to vote. If you've already voted and you get a text, please just delete it and please accept my apologies. I know it's a pain, but we want to make sure everybody gets this opportunity. We're hoping that we're going to get our clients voting wrapped up within the next 10 days, and then you won't have to hear about it anymore. Thanks, everyone. And again, if you have any questions, please call me, email me, or reach out to one of our team members.
I have one question. question.
Oh,
Can I
yes, before we get off. Yeah, Sean, go ahead.
One last question. When it comes to turning in our lists for this claim and everything, if it passes and does everything, when is the earliest you'd like us to submit them to you, or where do we submit? Obviously, I think they're going to you, correct?
Right, yeah. Please submit them to us as soon as you're ready. My goal in a perfect world, I would have everyone's claims ready to go the day that it opens for business. So if the claims administrators say August 1st is the day we start accepting, I would love to be able to present all 7,000 on that day. Realistically, most people are going to need more time, but if you want to send us yours tomorrow, we will work it up and you'll be right there in the queue ready to go as soon as they open it up.
Great answer. Thank you.
All right. Take care, everybody.
Yeah.